Okay, hello everybody. This is Trespass My Eyes doing another video on the California Public Records Act. This is going to be Chapter 0.5. It's covering the new additions to the Cpra for next year. Okay, so the new additions for next year, let's go over them. This is from the website of AALRR, Atkinson, Anderson, Loya, Rudd, and Romo. They're a law corporation, and they're basically going over the new bills, which were signed into law, so they're going to go into effect. We'll talk about it. So this is Governor Brown signed Senate Bill 1421 and Assembly Bill 748, making certain peace officer records subject to disclosure under the California Public Records Act. Sorry for my voice. Can't get rid of this damn cold. Plus, my asthma's been crappy lately. So anyway, this is put out on 10/9/2018. So it goes over, Governor Brown, Moonbeam, as we call him here in California, signed these few bills, and it's called the Public Record. Well, here I highlighted the important parts. The public will now have access under the Cpra to records of officer-involved shootings, use of force incidents, and sustained findings of sexual assault and dishonesty. So SB 1421 goes into effect January 1st, 2019. It's going to, currently the Penal Code 832.7.8 make all peace officer personnel files confidential and only allow access to these files in criminal, civil, and administrative proceedings pursuant to the Evidence Code. Blah, blah, blah. Effective January 1st, 2019, SB 1421 amends the Penal Code, so I guess it 832.7, to allow disclosure pursuant to the Cpra request for records in 4 categories. Records relating to the report, investigation, or findings of any incidents involving the discharge of a firearm at a person by a peace officer or custodial officer. Records relating to the report, investigation, or findings of any incident in which the use of force by a peace officer or custodial officer against a person resulted in death or great bodily injury. Number 3, records relating to an incident in which a sustained finding was made by any law enforcement agency or oversight agency that a peace officer or custodial officer engaged in sexual assault involving a member of the public. And they define sexual assault for the purposes of this definition: the propositioning for or commission of any sexual act while on duty is considered a sexual assault. Number 4, records relating to an incident in which a sustained finding, so these last two or 3 or 4, you need sustained findings, was made by any law enforcement agency or oversight agency, dishonesty by a peace officer or custodial officer directly relating to the reporting, investigation, or prosecution of a crime. So if their police report was sustained finding that it was dishonest, those will be disclosed. Or directly relating to the reporting of, investigation, or misconduct by another peace officer or custodial officer. I should start at the top of this. I should say I am not a lawyer. I'm just reading this, and I may throw an opinion out there, but trust me, I'm not a lawyer in any way, shape, or form. Including but not limited to any sustained finding of perjury, false statements, filing false reports, destruction, falsifying, or concealing of evidence. Here's another highlighted part. When an investigation or incident involves multiple officers, the information set forth in categories 3 and 4 above is only released if it involves a sustained finding against that officer. However, factual information about other officers involved or statements they made may be released even without a sustained finding against that officer if such information was relevant to the sustained finding against the other officer. Thus, officers who are witnesses to incidents could have their statements released if the investigation against the subject officer resulted in a sustained finding against the officer under categories 3 and or 4 above. And then let's go down to the next highlighted section. Disclosure may be delayed while a criminal or disciplinary case is pending for use of force or officer-involved shooting cases. If there is a pending criminal or disciplinary case pending, I said pending twice, against an officer for use of force resulting in great bodily injury or death, or for the discharge of firearm at a person, the agency may delay disclosure or otherwise discoverable information under the following four categories. And it basically goes why it may delay it, and usually it's about if it's got an investigation or a criminal proceeding happening. So these things may be delayed, the release. Okay, here's SB 1421 that amends Penal Code Section 832.8. So in addition to 832.7, which was just talked about, SB 1421 also sets forth new language in 832.8, the Penal Code, what sustained and unfounded means with respect to investigations. Sustained means a final determination by an investigating agency, commission, board hearing. Officer, arbitrator, blah, 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 government code. Actions of the peace officer or custodial officer were found to violate law or department policy. Department policy. Unfounded means that an investigation clearly establishes that the allegation is not true. Due to the fact that sustained is defined as a final determination following an investigation and I highlighted opportunity for appeal, agencies must be cautious not to release any information set forth in categories 3 and 4 above if an officer has filed administrative appeal of the findings. Okay, here's Assembly Bill 748. Oh, well, I guess I was wrong. SB 1421 is about the above, and they just define. All right, so here's another new one, AB 748, not effective till July 1st of 2019. In addition to 1421, Governor Brown also signed 748. Currently, the Cpra exempts from disclosure records of investigations by state or local agencies. AB 748 amends the Cpra to mandate disclosure of video or audio recording that relates to a critical incident. Critical incidents are defined as an incident involving the discharge of a firearm at a person by a peace officer or custodial officer. An incident in which the use of force by a peace officer or custodial officer against a person resulted in death or great bodily injury. So I guess the second bill is about video and audio. The first bill is about records of officers involved. So redaction or withholding. 748 allows agency to withhold the release of video without limitation as to time. I guess that means forever. If it can demonstrate that the public interest, quotes, withholding a video or audio recording clearly outweighs the public interest in disclosure because the release of the recording would, based on the facts and circumstances depicted in the recording, violate the reasonable expectation of privacy of a subject depicted in the recording. In such a case, the agency must provide the requester of the record with a specific basis for the expectation of privacy and the public interest served by withholding. Any agency may use redaction technology to obscure those portions of the recording that protect an individual's privacy. And then agency may delay disclosure while a criminal or disciplinary case is pending, kind of just like the one above. So, and then they talk about the conclusions. So that's it. Basically, I went over it quickly. These will come into effect January 1st and July 1st, I believe it was, next year. So, it gives you more tools in the toolbox. Thanks for listening. And I will post a copy of this and a link to this law firm's website in the description. A copy of this will go on to my First Amendment auditor files. The link is on my homepage. Talk to you later and be safe. And just wanted to go over how to get to these files. Here you go. Yeah, go straight to the my homepage, First Amendment auditing files. And this file that we just talked about is in the state, California. And where did I put it? Here it is, Senate Bill 1421 and Assembly Bill 748. Also a new file here, I put in the Cpra request template. It's kind of a generic for California Public Records Act template. Thanks to Huckleberry Auditor for helping me out on that. Talk to you later.